Mr. President.
The Senator from New Hampshire.
I ask that the quorum call be vitiated, please.
Without objection.
Thank you, Mr. President. I ask unanimous consent that Dennis DeZiel, a defense fellow in my office, be granted floor privileges during the consideration of Senate Bill 1867.
Without objection.
Thank you, Mr. President. I yield the floor.
Suggest the absence.
I suggest the absence of a quorum.
The clerk will call the roll.
Mr. Akaka. Mr. President.
Senator from Oregon.
Thank you, Mr. President. I ask unanimous consent to set aside the quorum call.
Without objection.
Mr. President, I ask unanimous consent that the pending amendment be set aside, and that I can call up en bloc 1239, 1256, 1257, and 1258.
Without objection. Clerk will report.
The Senator from Oregon, Mr. Merkley, proposes en bloc amendments number 1239, 1256, 1257, and 1258.
Mr. President, I ask that further reading of the amendments be set aside.
Without objection.
Thank you, and I call for the regular order.
The amendment's now pending.
Mr. President, I note the absence of a quorum.
Clerk will call the roll.
Mr. Akaka.
President.
Senator from Michigan.
Mr. President, I would ask that further proceedings under the quorum call be dispensed with.
Without objection.
Mr. President, in a short while, I hope that we will have and expect that we will have some amendments that have been cleared on both sides that we're going to be able to offer and hopefully adopt. And what I thought I would do now is make a fairly lengthy statement about the statements which have been made relative to the detainee provisions in Senate Bill 1867. First, I want to comment on the statements that were made in the statement of administration policy, and this is the so-called SAP, and so I'll be referring to SAP during these comments, and when I use that term, it's relative to, and the acronym means, Statement of Administration Policy. First and I'm now going to first quote exactly from the administration SAP, and then I'm going to comment and show why these statements that I am referring to are inaccurate. Quote from the SAP, Section 1031 attempts to expressly codify the detention authority that exists under the Authorization for Use of Military Force, the so-called AUMF. The quote continues, the authorities granted by the AUMF, including the detention authority, are essential to our ability to protect the American people from the threat posed by al-Qaeda and its associated forces, and have enabled us to confront the full range of threats this country faces from those organizations and individuals, close quote. Well, Mr. President, given how important the administration says these authorities are, it should be helpful to have them codified so that they can stand on the strongest possible footing. Next quote. Because the authorities codified in this Section 1031 already exist, the administration does not believe codification is necessary and poses some risk. The quote continues, after a decade of settled jurisprudence on detention authority, Congress must be careful not to open a whole new series of legal questions that will distract from our efforts to protect the country. The quote continues, while the current language minimizes many of those risks, future legislative action must ensure that the codification in statute of express military detention authority does not carry unintended consequences that could compromise our ability to protect the American people, close quote. Well, Mr. President, Section 1031 was written by administration officials for the purpose of codifying existing authority. The description of persons covered is identical to the position taken by the administration and upheld in the courts. The provision specifically provides that nothing in the provision either limits or expands the authority of the President or the scope of the AUMF. Now, it's also worth noting that the SAP does not support the argument made by some senators that Section 1031 creates a new or unprecedented authority. On the contrary, the Statement of Administration Policy, the SAP, acknowledges that the provision codifies existing law. Now, this is hardly surprising since the committee accepted all of the administration's proposed changes to Section 1031. Now, I'm continuing to read from the Statement of Administration Policy, quote, the administration strongly objects to the military custody provision of Section 1032, which would appear to mandate military custody for a certain class of terrorism suspects. This unnecessary, untested, and legally controversial restriction of the President's authority to defend the nation from terrorist threats would tie the hands of our intelligence and law enforcement professionals, close quote. Well, Mr. President, it's interesting that the SAP states that the amendment would, quote, appear to, quote, mandate, close quote, mandate military custody. In fact, it does not mandate military custody and does not tie the administration's hands because it includes a national security waiver which allows suspects to be held in civilian custody. Next quote. Moreover, applying this military custody requirement to individuals inside the United States, as some members of Congress have suggested is their intention, would raise serious and unsettled legal questions and would be inconsistent with the fundamental American principle that our military does not patrol our streets, close quote. Well, the administration itself asked that we delete limitations in Section 1031 on the applicability of detention authority inside the United States that would have excluded U.S. citizens and lawful residents based on conduct taking place inside the United States to the extent authorized by the Constitution. The exact words were, except to the extent authorized by the Constitution. Now, if it is appropriate to authorize military detention inside the United States under Section 1031, it is not at all clear what, quote, serious and unsettled legal questions, close quote, in this narrow category of cases could be raised by requiring such detention subject to a national security waiver. Further, nothing in Section 1032 would require or even permit our military to, quote, patrol our streets, close quote. Section 1032 applies by its very terms only to a person, quote, who has been captured in the course of hostilities, close quote, authorized by the AUMF. The provision has no applicability to a person who has not already been so captured and does not speak to the question of when or where such a capture might be authorized. The provision does not give the military authority to make arrests or conduct any law enforcement functions inside the United States. Next quote. We have spent 10 years since September 11, 2001, breaking down the walls between intelligence, military, and law enforcement professionals. Congress should not now rebuild those walls and unnecessarily make the job of preventing terrorist attacks more difficult, close quote. Well, in answer to that, it is not clear what walls the administration thinks the provision builds. Nothing in this provision limits the participation of law enforcement or intelligence professionals in the interrogation of detainees in military custody or vice versa, or the sharing of information. Next quote. Specifically, the provision would limit the flexibility of our national security professionals to choose, based on the evidence and the facts and the circumstances of each case, which tool for incapacitating dangerous terrorists best serves our national security interests. Well, Mr. President, the provision does not limit the flexibility of the executive branch to choose the appropriate tool for taking on terrorists. On the contrary, the provision expressly directs the President to establish procedures for making determinations of coverage, authorizes the executive branch waiver of military detention requirements where they do apply, and expressly authorizes the transfer of any detainee to civilian custody for trial. The next quote from the SAP, quote, "The waiver provision fails to address these concerns, particularly in time-sensitive operations in which law enforcement personnel have traditionally played the leading role," close quote. Well, Mr. President, it is not clear why the administration, why the administration thinks that the use of a waiver would be problematic in, quote, time-sensitive operations, close quote. The need for a waiver is not triggered until the executive branch determines that an individual is covered. The President has control over who makes these determinations, how they are made, and when they are made, so the executive branch should not be faced by a determination of coverage for which it is not ready. And even if for some reason executive branch officials were not ready to deal with their own determination, the provision specifically provides that a determination of coverage may not be used to interrupt ongoing surveillance, intelligence gathering, or interrogation sessions. Next quote from the SAP. These problems are all the more acute because the section defines the category of individuals who would be subject to mandatory military custody by substituting new and untested legislative criteria for the criteria that the executive and judicial branches are currently using for detention under AUMF in both habeas litigation and military operations. Such confusion threatens our ability to act swiftly and decisively to capture, detain, and interrogate terrorism suspects and could disrupt the collection of vital intelligence about threats to the American people, close quote. Well, the SAP is wrong. Detention under Section 1032 is expressly limited to persons for whom detention is authorized under criteria currently used by the executive branch and the courts. The, quote, new and untested legislative criteria, close quote, about which the SAP expresses concern, is language narrowing the application of the provision to a small category of those for whom detention is already authorized. Also, because the provision addresses only the question whether an individual should be transferred to military custody after capture, it is not clear how it could possibly threaten the ability of executive branch officials to, quote, act swiftly and decisively to capture, close quote, anybody. Also, because the provision expressly states that it may not be applied to interfere with an ongoing surveillance, intelligence gathering, and interrogations, it is not clear how it could possibly threaten the ability of executive branch officials to, quote, interrogate terrorism suspects, close quote, or disrupt, quote, the collection of vital intelligence about threats to the American people, close quote. The next quote from the SAP. Rather than fix the fundamental defects of Section 1032 or remove it entirely, as the administration and the chairs of several congressional committees with jurisdiction over these matters have advocated, the revised text merely directs the President to develop procedures to ensure the myriad problems that would result from such a requirement do not come to fruition, close quote. Well, Mr. President, the administration reviewed the language directing the President to develop procedures, and they made several suggestions for improvements to that language. The committee adopted all of the administration's suggestions. The remaining change suggested by the administration, which the committee did not adopt, was a proposal to limit the application of the provision to persons captured, quote, abroad. This difference does not constitute a myriad of problems which are complex or hard to understand.
Can you do that?
No, it's okay.
Why?
Mr. President, I would ask unanimous consent at this point in my remarks that the senator from Vermont be recognized to call up a couple of amendments and that they not be interfering with my remarks in the record.
Without objection.
And then I'd recognized again.
Mr. President, first I thank the senior senator from Michigan for his usual courtesy. I ask unanimous consent. Pending amendment be set aside. Amendment number 1087, Leahy FOIA amendment, be called up and then set aside.
Without objection. Clerk will report.
The senator from Vermont, Mr. Leahy, proposes amendment number 1087.
And then, Mr. President, I consent to call up the Leahy-Grassley Amendment 1186, the Fighting Fraud to Protect Taxpayers Act. That be called up and then set aside.
Without objection. Clerk will report.
The senator from Vermont, Mr. Leahy, for himself and Mr. Grassley, proposes amendment number 1186.
And that my statements be included in the record as though read.
Without objection.
Thank you. And again, I thank the distinguished senior senator from Michigan. I'm done.
Mr. President, did we return to the regular order at the end of his remarks?
The Senate does return to regular order.
Okay. Mr. President, I now would ask unanimous consent that the senator from Oregon be recognized for up to 10 minutes for remarks, that they not be an interruption of my remarks in the record, and then I be recognized to return after his remarks.
Without objection.
I want to thank the chairman of the committee, Senator Levin, as well. I very much appreciate his good work and his courtesy on this as well. Mr. President, I ask unanimous consent for the pending amendment to be set aside and to call up Amendment 1176 and Amendment 1253 en bloc.
Without objection. Clerk will report.
I'm sorry, you McKellar amendment. You got the wrong number on you.
Senator from Oregon, Mr. Wyden, proposes amendments en bloc numbered 1160 and 1253.
Mr. President.
Senator from Oregon.
Mr. President, I would also ask unanimous consent that Joel Garrison, a defense legislative fellow in our office be granted floor privileges for consideration of these amendments.
Without objection.
Mr. President, this First Amendment has previously passed the Senate, and it would solve a problem created by the lawyers at the Pentagon who, in effect, at the last minute on a critical issue for eastern Oregon, pulled the rug out from under our communities. Mr. President, when we have a problem or a conflict in our state, we solve it the Oregon way, by finding consensus and building common ground. That's why when it became apparent 20 years ago that the U.S. Army's chemical depot in Umatilla, Oregon would be closing once all the chemical weapons were destroyed, the community leaders gathered all of the critical organizations together and began the process of planning what to do with the land once the facility closed. The depot straddles 2 counties, several cities, and historic tribal lands. So suffice it to say, there are a lot of folks at home in my state who are interested in what happens to the land. As progress was made in destroying the weapons at Umatilla, we were able to find consensus. The federal government helped. More than $1 million in grants were made available to move the project along. And when the facility was listed in the 2005 BRAC recommendations for closure, the Pentagon eventually recognized the organizations that were involved in building this consensus in an official local reuse authority. Everything appeared on track until last summer. And that was, in effect, the time when, at the last moment, the Pentagon changed the rules. After decades of planning and $1 million was spent in pulling together an extraordinary community-wide consensus, a lawyer at the Pentagon decided to reinterpret the law and declared that the 2005 BRAC report, which became law when Congress didn't pass a resolution of disapproval, didn't matter. He decided that the Umatilla depot would be closed outside of the BRAC authority because the last of the chemical weapons wouldn't be destroyed until after the 6-year limit for completion of BRAC actions. What this lawyer either didn't know or choose to ignore is this was precisely the intention of the BRAC Commission when they put the depot on the closure list. The BRAC report discusses the fact that the mission of destroying the chemical weapons wouldn't be completed until after deadline. On page 239 of the report, the Commission found that Secretary Rumsfeld's assertion that the chemical demilitarization mission at Umatilla would be complete by the second quarter of 2011 was optimistic. The Commission wrote an examination of status information for the depot's mission completion and subsequent closure revealed that dates may slip beyond the 6-year statutory period for completing BRAC actions. Therefore, the Commission took the Secretary of Defense's recommendation, close Umatilla Chemical Depot, and changed it to, on completion of the chemical demilitarization mission in accordance with treaty obligations, close Umatilla Chemical Depot, Oregon. These facts make it clear that the Commission did not, as this Pentagon lawyer claimed, make a conditional recommendation that the facility only be closed if the chemical demilitarization mission is completed by September of 2011. Rather, the Commission acknowledged that the closure will have to happen when the demilitarization mission is complete, even if that is after September 2011. And that decision by the Commission became law. It's also important to note, Mr. President, the Commission was aware that the demilitarization mission had a deadline of its own. Under the terms of the Chemical Weapons Convention Treaty, Umatilla had to complete the mission by April 29, 2012. The fact is they actually beat the deadline. The depot should be closed under BRAC so that the will of the community in the form of this local reuse authority and the will of Congress and the BRAC law will be taken into account. The Pentagon has to implement the law as it is, not as it wants it to be. But since the lawyers at the Pentagon seem to think there is some ambiguity, I seek to clarify it for them with my amendment. The amendment would require the Pentagon to follow the BRAC Commission's report and close the Umatilla depot under BRAC. Once again, Mr. President, I'd like to note that this has already passed the Senate once. I'm very appreciative of Chairman Levin, Senator McCain, all our colleagues who are involved, and I want to thank them. Then very briefly, Mr. President, and I appreciate the courtesy of Chairman Levin on this matter, I want to discuss my second amendment, which I call the Soft Landing Act. And I think we all recognize the extraordinary contributions that are made by our Guard and Reserve. They do tour after tour after tour, and we all understand that never in our nation's history has the American military relied more on the Guard and Reserve than it has in the last 10 years. More than 800,000 members of the Guard and Reserve have been called to active duty since 9/11, and as I indicated, they are serving repeated tours in Iraq and Afghanistan. And I feel very strongly that the period from when a Guard member is holding a rifle to the time when they're holding a child back at home in beautiful Oregon, there's not sufficient time being given in order to have what I call a soft landing, an opportunity to reintegrate and get your life back in order and get back into the community. And what we have is a very abrupt, period where a soldier who's faced the trauma of combat comes right back to the community and really doesn't get an adequate time to readjust. Literally, in a matter of days, these guardsmen go from holding a gun in the chaos of a combat zone to holding their child in the serenity of their own home. It is a difficult transition, and I just want to make the point that it is a very different, transition than most of our active duty, troops have. Our active duty troops are in a position, many of them come back to communities that are close to facilities, close to bases, a variety of support services, and many of the guardsmen come back to communities that don't have the support of a large base. And it just seems to me that the amount of personal and professional requirements that are placed on these patriotic, courageous Americans who serve in the Guard and Reserve warrant our making it possible for them to have what I call a softer landing, getting back into their home communities. And I'm very appreciative of the fact that Chairman Levin has given me the opportunity to discuss this briefly. He and I and his staff have talked about this before, but I'll just close by saying that to have all these men and women who have served with great valor in the Guard and Reserve coming home, we all understand that they already face an unacceptably high unemployment problem. We know that in many instances they feel strongly about taking the time to get mental health services, to get back together again with their families, and very often the time period simply is insufficient for Guards members, to come home, and right now the reality can be pretty harsh. They go and serve their country. Their family is concerned about their being in harm's way for months on end, and then they come back with no job and no source of income to be able to support their families. So what this legislation does, the soft landing for Guard and Reserve members, is allow returning Guardsmen and Reservists to take up to 45 days. It is not a long period of time, Mr. President, to come back, get home, get their lives in order, and still get paid. My view is this is part of the promise that we have made in this country to take care of our troops. They did their best for us. We ought to do our best for them, and I am very hopeful that the soft landing amendment, Amendment 1253, will be included when this legislation passes here in the United States Senate. Mr. President, again, let me express my appreciation to Chairman Levin. I know he's speaking on an important matter. I want to thank him for his courtesy and thank him for working with me on both of these amendments, the one involving the Umatilla Depot and the soft landing legislation, and I look forward to working with him on these matters. He is our authority on these issues, and I appreciate his courtesy. Mr. President, I yield the floor.
Mr. President.
Senator from Michigan.
President, first let me thank the Senator from Oregon, and we're happy to work with him. He's very deeply into these issues and so many other issues, and so his contribution is well known to all of us in the Senate. We're happy to work with him on these matters. Mr. President, again, without interrupting my comments, I would ask unanimous consent that the legislative fellow in the office of Senator Conrad, Air Force Major Jason Jensen, be granted floor privileges for the duration of the debate on S. 1867.
Without objection.
Mr. President, returning now to the comments that I'm making on the statement of the administration position. We're on Section 1032 in finishing the statements, comments on that, and my comments on their comments. This is the last comment that they make on that section. Quote, requiring the President to devise such procedures concedes the substantial risks created by mandating military custody without providing an adequate solution. As a result, it is likely that implementing such procedures would inject significant confusion into counterterrorism operations, close quote. Well, Mr. President, the language referred to was included to address concerns expressed by the administration. Now, that does not in any way constitute an acknowledgement that the concerns were valid. Whether these concerns were valid or not, they have now been resolved by specific language in the revised provision. Continuing, quote, the certification and waiver required by Section 1033 before a detainee may be transferred from Guantanamo Bay to a foreign country continue to hinder the executive branch's ability to exercise its military, national security, and foreign relations activities. While these provisions may be intended to be somewhat less restrictive than the analogous provisions in current law, they continue to pose unnecessary obstacles, effectively blocking transfers that would advance our national security interests and would, in certain circumstances, violate constitutional separation of powers principles. The executive branch must have the flexibility to act swiftly in conducting negotiations with foreign countries regarding the circumstances of detainee transfers, close quote. Well, Mr. President, the provision is not only, quote, intended to be somewhat less restrictive, close quote, than provisions that are included in previous authorization and appropriation acts signed by the President. It is less restrictive. Unlike last year's bill, this provision includes a waiver which allows the administration to proceed with a transfer even if the certification requirements cannot be met. Now, Congress has expressed strong concerns about recidivism among Gitmo detainees who have been released in the past. It cannot be in our national security interests to act swiftly if we fail to provide adequate safeguards against terrorists rejoining the fight against us. In discussions of this issue, administration officials have made a single priority request that the provision be made a one-year limitation instead of a permanent limitation, and the committee agreed to that change. Section 1034's ban, and I'm now continuing to quote from the SAP, quote, Section 1034's ban on the use of funds to construct or modify a detention facility in the United States is an unwise intrusion on the military's ability to transfer its detainees as operational needs dictate, close quote. Well, Mr. President, this provision is the same as the provisions included in last year's authorization and appropriation acts, which were signed by the President. And in discussions of this issue, administration officials made a single priority request that the provision be made a one-year limitation instead of a permanent limitation. The committee agreed to that change. The next quote from the SAP, quote, Section 1035 conflicts with the consensus-based interagency approach to detainee reviews required under Executive Order number 13567, which establishes procedures to ensure that periodic review decisions are informed by the most comprehensive information and considered views of all relevant agencies, close quote. Mr. President, Section 1035 does not conflict with the executive order of the interagency review process established in the executive order. Rather, it requires the issuance of procedures to implement the review process required by the executive order. The executive order states that a Gitmo detainee will not be released if the interagency process results in a unanimous recommendation against release. The executive order states that a Gitmo detainee will be released if the interagency process results in a unanimous recommendation for release. But it is silent as to what happens if the process does not result in a unanimous recommendation. The provision in the bill addresses that issue by providing that no Gitmo detainee will be released without the consent of the Secretary of Defense. This does not contradict the executive order. It is a truism, since nobody can be released without agreement of all of the agencies. And in discussions with the administration, in discussions with the committee, administration officials did not even raise this provision as a priority issue. And finally, on the statement of administration policy, the SAP, quote, Section 1036, in addition to imposing onerous requirements, conflicts with procedures for detainee reviews in the field that have been developed based on many years of experience by military officers and the Department of Defense, close quote. Mr. President, the only new requirement imposed by Section 1036 is the requirement for a military judge and legal representation for any detainee who will be held in long-term custody. In discussions with the committee, the administration did not object to this new requirement. On the contrary, the only change requested by the administration in this provision was to strike the words, quote, long-term. The committee did not agree to this proposed change because it would have been onerous to impose this requirement in the case of all detainees, including those who are captured and released or held on a short-term basis.
Did I read this? No, it goes in here, not in there.
Mr. President, I now want to move to my comments on some of the statements of the senior senator from California yesterday. The first comment of Senator Feinstein that I want to address is the one where she said, quote, Section 1031 needs to be reviewed to consider whether it is consistent with the September 18, 2001 authorization for use of military force. On this one, Mr. President, the committee accepted all of the administration's language changes, which were written to ensure that the provision is consistent with the AUMF. The provision specifically states that it does not, quote, limit or expand the authority of the President on the scope of the AUMF, close quote, and the SAP on the provision states that, quote, the authorities codified in this section already exist under the AUMF. The next quote of the senator from California is the following, that Section 1031, quote, would authorize the indefinite detention of American citizens without charge or trial. Do we want to go home and tell the people of America that we're going to hold them if such a situation comes up without any review, without any habeas? Close quote. Mr. President, the committee accepted all of the administration's proposed changes to Section 1031, and as the administration has acknowledged, the provision does nothing more than codify existing law. Indeed, as revised pursuant to administration recommendations, the provision expressly, quote, affirms an authority that already exists. The Supreme Court held in the Hamdi case that existing law authorizes the detention of American citizens under the law of war in the limited circumstances spelled out here, so this is nothing new. Now, the initial bill reported by the committee included language expressly precluding, quote, the detention of citizens or lawful resident aliens of the United States on the basis of conduct taking place within the United States except to the extent permitted by the Constitution of the United States, close quote. The administration had asked that this language be removed from the bill. 1031 does not refer to habeas and in no way limits habeas, nor could it. No American can be held in military detention without habeas review, and no non-American can be held in military detention inside the United States without habeas. For non-Americans outside of the United States, the bill requires the administration to establish review procedures, including, for the first time, a military judge and access to a military lawyer for the status determination. Now, the next quote of the senator from California is the following, quote, under Section 1032, any non-citizen al-Qaeda operative captured in the United States would be automatically turned over to military custody. Military custody for captured terrorists may make sense in some cases, but certainly not all. Well, Mr. President, Section 1032 does not mandate military custody. It does not tie the administration's hands because, and this is critically important, it includes a national security waiver which explicitly allows any suspect to be held in civilian custody. Nothing is automatic. The administration would have the discretion to waive military detention and hold a detainee in civilian custody if it decided to do so. The next quote. In the case of Najibullah Zazi, if the mandatory military custody in the Armed Service Bill was law, the committee bill was law, all of the surveillance activities, all of what the FBI did would have to be transferred immediately to the military. Then the government would have been forced to split up co-defendants, even in cases where they otherwise could be prosecuted as part of the same conspiracy, she said. Zazi was a permanent legal resident. His co-conspirators were both U.S. citizens. They would be prosecuted on terrorist charges in federal criminal court, but Zazi himself would be transferred to military custody. Two different detention and prosecution systems would play out and could well complicate a unified prosecution, she said. Well, Mr. President, it is not accurate to say that everything the FBI did in the Zazi case would have had to be, quote, transferred immediately to the military. First, it is not at all clear that Zazi was covered by the provision because we don't know that he was al-Qaeda. And in any event, there is an exclusion because he's a lawful resident alien of the United States. Second, until a coverage determination was made, no transfer would be required, and the President would decide how and when that determination would be made. And finally, even if Zazi were somehow determined to be covered, the requirement could have been waived, and Zazi could have been kept in civilian custody in the discretion of the executive branch. And also, as to this statement that the executive branch would be forced to split up co-defendants, and there couldn't be a conspiracy case. The executive branch would not be forced to split up co-defendants in the Zazi case, even if he were covered by the provision or in any other case. That's because the provision includes a waiver that would have allowed him to be held in civilian custody from the outset if the executive branch officials desired to do so, and also because the provision expressly authorizes the transfer of any military detainee to civilian custody for trial in the federal courts, even without a waiver. So executive branch officials are always able to consolidate cases, should they decide to do so, in the federal courts. Now, the next statement, which the senator made, was the following: that the Department of Justice has said that approximately one-third of the terrorists charged in federal court in 2010 would be subject to mandatory military detention absent a waiver from the Secretary of Defense. But, Mr. President, taking the Justice Department at its word, there have been approximately 300 terrorist cases in federal court over the last 10 years, or about 30 a year. One-third of that number would be just 10 cases a year in which the executive branch officials would have to make determinations of coverage and, if necessary, exercise their waiver authority. Even that number appears to be exaggerated. Cases of attempted al-Qaeda attacks on American soil have been highly publicized and receive extensive scrutiny, understandably, in Congress. We are not aware of more than half a dozen cases total over the last decade. The reason that the debate on this issue always seems to come back to the same handful of cases appears to be that there only are a handful of cases that are covered by this provision potentially. Now, the administration contends, in her next quote, that the mandatory military custody is unwise because our allies will not extradite terrorist suspects to the United States for interrogation and prosecution, or even provide evidence that suspected terrorists or even provide evidence about suspected terrorists if they will be sent to a military brig or Guantanamo, close quote. Mr. President, this provision expressly states that the waiver authority may be used to address these concerns and to assure an ally that a suspect will not be held in military custody if transferred to the United States, and if that assurance is necessary to obtain that transfer. Administration officials suggested a wording change to preclude misinterpretation of this provision, and the committee adopted the very wording proposed by the administration. Now, the next quote of the senator from California is that Section 1033 essentially establishes, quote, a de facto ban on transfers of detainees out of Guantanamo, even for the purpose of prosecution in United States courts or in other countries. Well, Mr. President, there is no limitation at all in the bill on the transfer of Gitmo detainees to the United States for trial or for any other purpose. And with regard to the transfer to other countries, Section 1033 is less restrictive than current law, which was signed by the President. The next quote that I would address is the following, that, quote, Section 1033 requires the Secretary of Defense to make a series of certifications that are unreasonable and candidly unknowable before any detainee is transferred out of Guantanamo. Again, the quote continues, an example, the administration proposed eliminating the requirement that the Secretary of Defense certify that the foreign country from whence the detainee will be sent is not facing a threat that is likely to substantially affect its ability to exercise its control over the individual. Now, Mr. President, the same language was included in last year's authorization and appropriation bills that were signed by the President. We added a waiver provision this year to make it easier to transfer detainees. And in discussion with the committee, the administration made a single priority request on this issue, that the provision be made a one-year limitation instead of a permanent limitation, and the committee agreed to that change. Finally, Mr. President, the last quote of the senator from California from yesterday that I'm going to address is the following, quote, "In March, the President issued an executive order that laid out the process for reviewing each detainee's case to make sure indefinite detention continues to be an appropriate and preferred course. Section 1035 essentially reverses the interagency process created by the President's order." Mr. President, this was the same allegation made by the Statement of Administration Policy. It is erroneous, and I addressed the answer to that allegation in my remarks a little earlier today relative to the Statement of Administration Policy, the SAP, so I'm not going to repeat the answer, but I would refer anyone reading these remarks to go back to the comments on that Statement of Administration Policy statement, similar to the statement of the senator from California, which I addressed at that time. I appreciate the patience of our presiding officers. This was a long statement, but I think it's essential that we understand that there are issues here that need to be debated and should be debated. But there is nothing but confusion created in an issue that is already complex when misstatements are made about what is in the bill of the committee and what is not in the bill of the committee. The words in the committee bill are words that are clear. They need to be debated, but they should not be exaggerated or misinterpreted. This is an important debate. We had a good debate yesterday, and I expect we'll complete this debate on Monday so that we can vote on these detention provisions and amendments relative thereto of Senator Udall, hopefully on Monday night. And I yield the floor.